Here's part 2 of our most recent Legal AI Live on LinkedIn. If you missed part 1, make sure to go subscribe at legalailive.com and check out our YouTube channel or Legal AI Live on any podcast app to catch part 1. Follow the Legal AI Live page on LinkedIn to watch us live. Without further delay, here's part 2.
So Jonathan, let's get some of your thoughts on this.
Yeah, this is something I think a lot about. And when I think about it from where AI is today versus where AI will be in 2 to 5 years. I think Damien and everybody else did a really great job of explaining kind of conceptually from an economic standpoint how today's models are already and will continue to impact the practice of law. But when I think about it, especially considering the basis of the conversation is the exponential growth in, if there's no regulation, it keeps growing like a hockey stick. That, in 2 to 5 years, let's say we have an AI agent that's capable of performing legal tasks at a highly competent level, right? And so now you have essentially a supply of competent legal help that approaches infinity, and it's going to eat up the 92% of the market that Damien touches on really, really fast. And so then you have to ask yourself, what's the world look like if we have an infinite supply of competent legal help and the demand will eventually teeter out? I mean, we won't have an infinite demand, right? And so, when you take that from a consumer standpoint, especially a sophisticated consumer like, I don't know, State Farm or country companies in my world, then you say to yourself, these people aren't going to pay $350 an hour for competent legal help if they can pay pennies an hour, right? And so I think that the comparison I make when I think about this is the education system in the United States. You have, especially K through 12, I'm a parent, so I think a lot about it. We have what's essentially free education. In other words, as a parent, I can put my kid in a public school and it's free. But that doesn't mean that public school or private schools don't exist. And what private schools have done is they take the same product, education, something I can get for free, but they add a value proposition. Maybe that value proposition is somebody's religious and they want their kid to be able to pray in school. Maybe their kid, they feel it's safer. Maybe they feel it's a better education. And so I think law firms are going to have to do that. Is in the next 2 to 5 years, as we move into an agianic AI that's capable of performing legal tasks at a highly competent level, lawyers are going to have to figure out what value proposition do humans add to the equation. And a really obvious low-hanging fruit here is we can appear in court. Okay, so I think a lot of people start to move towards things that require in-person appearances. Obviously, we're always going to have high-level maybe mergers and acquisitions that we're just not going to trust these systems with at first, at least. And so we have to, add that as a value prop. But we need to move into a world where we realize that competent legal help is free or next to free. And what's the value add that we as attorneys can formulate in order to convince somebody to continue to pay us to do the job? Because, Damien is right that we're going to be able to lower our fees to help all of these people, but this is a really stressful job. It's a really hard job. And there comes a point where the fees are so low, who's going to want to do it? And so we have to kind of balance that, right? And I think that the way to balance that is to just assume free legal help. That's going to be there. And so as lawyers, what can we add that makes paying for it worthwhile?
I love Jonathan's kind of we'll call this path number 1 of the future world that might happen. I'm going to offer a maybe more optimistic path number 2 of where the world could go. And rather than, have the, race to the bottom where all the legal work goes to zero, I'm going to maybe shoot for abundance. And because of this is Jevons paradox. That is, we thought that LED light bulbs were going to save us a lot of energy, but they're so cheap, we just leave them on all the time. So Jevons paradox means that the cheaper the unit cost of something, the more society uses of that. That LED light bulbs are too cheap to measure. And what if legal work were too cheap to measure? That is, what if today I say, gosh, every time I call Jonathan, it costs me $500. I'll forget it. I'll risk it, right? That's the old world. But if the new world says, no, it goes from $500 to $50, I'm going to call you every day. And in fact, I'll spend more than the $500 in the aggregate. So this is Jevons paradox, is that if we shrink the unit cost, society uses more of it. But then what am I paying Jonathan for? I'm paying for trust. That I'm not paying for what the case statute and regulation says, because those will be close to zero. But I'll be saying, Jonathan, in those closed door meetings, when you settled these cases, or when you negotiated with the other side, or when you negotiated with the regulator, what was happening in those closed door meetings? And that's what you're paying for, because I trust you as Jonathan to be able to say, this data that I can't get from ChatGPT. So what if Jevons paradox shrinks the cost of legal services, and then you're paying for the trust? Then you go from the slowest lawyer wins the race, which is something that is, if you spend $10 an hour or 10 hours in something, I spend 1 hour on it, you make more money with me. But that's only true for hourly lawyers. That's not true for Matthew because he does subscription fees. It's also not true for contingency fee, like you said. Also not true for flat fees. Also not true for in-house counsel. Also not true for government prosecutors and civil government lawyers. Also not true for the judiciary. For all of them, they have more work than there is time. So the less time they spend on something, the more money they make, or the less cost they have for the organizations. So I think that the future, it belongs to Matthew and subscription fees and flat fees and contingency fees and working in conjunction with client self-help. Because the in-house counsel tells me every day, one of them told me every time I thought about calling a law firm, I realized, I just asked Vincent. And Vincent gives a really good answer, an AI answer. And I give that answer to the business people, and the business person says, I asked the business person, hey, should I go to a lawyer external? They said, nope, this gives me what I need. This mitigates my risk. And that in-house counsel told me that law firm lawyer doesn't know why the phone stopped ringing or didn't ring. That I just didn't need them. So really, I think the law firms that don't get it, that they really think, this is something I have time to think about. Don't think about they're losing money left and right. So this is happening to you. My friend Casey Flaherty likes to say this is happening to you, or this is happening by you. So I'm really confident and happy that Jonathan and Matthew and people like them are making sure that this is happening by them rather than to them.
Yeah, I think the other thing that another possible road forward that lawyers need to think about, and this drove my own change from when I was doing estate planning, was that if you get the savvy clients and you get the competition, other people start to say, well, legal work is only X, and they shrink that. So you could make the argument right now, the only thing that really should be practice of law is an appearance in a court system dispute resolution. Okay. I won't make that argument, but people can certainly make the argument. So I think part of so my students start out saying, we're really worried that there's not going to be any careers for us in the future. Like the practice of law is not going to be what it is. And I'm like, no, what I think is, as happened in estate planning, we need to figure out how do we not get relegated to the most boring, the most repetitive, the most commodity work, and how do we keep the most interesting and exciting work that pull us into practice of law? And I think that's another way to think about AI that's not pure economics, but saying like, hey, I want a career that's fun. I want to practice at the top of my license. I don't want to have clients tell me like, hey, here's a bunch of boring things that has a really tight deadline. I don't want to think about this over the weekend, but could I hire you to do this, right? Or I don't want to do this thing where I say, if my CFO says we're moving hard on M&As, instead of considering, 20 deals next year, we're going to consider 500 of them. Well, we're not going to hire Skadden Arps to look at all of those because that's cost prohibitive. We say AI could do some screening, right? And then we would know what we needed to hire people for, and we could kind of scope properly. And so I think that's another potential way forward. And then, Greg, I'll ask you to talk about this, because I know from your boss, Bridget McCormick, that you've been thinking about this, is that we know that eBay is handling 80 million disputes. We know Amazon is probably 40 million. We know that MasterCard, Visa, Amex are settling a whole bunch of credit card disputes, and there's some other things out there. So probably, I'm guessing we could go as high as 200 million, what would be traditional small claims cases that are being settled outside the court system. If you think about that and say like, oh, wait, that's somehow unauthorized practice of law, and we dump those 200 million cases back into the U.S. court system, like what is going to happen? It's kind of like all this stuff has already happened, and what are we doing? What is the court system doing? And that's why, Greg, I think the stuff you're doing is so interesting, because most of the time in the business world, there's this dispute. I want to get it going. I want to move forward. I don't want to spend 4 years and millions of dollars, to get an answer that, especially these days, when we finally get the answer, the technology is irrelevant.
Mhm.
So, Greg, maybe you could talk about your thinking on the dispute resolution side, and maybe to the extent you can, some of what American Arbitration Association is thinking along those lines.
Yeah, so the AAA ICDR Institute, which is our internal think tank that I'm working pretty intently on, a couple of our focus areas are court-connected alternative dispute resolution and access to justice, and of course AI. And they all the Venn diagram really overlaps with those three, I think. And when we have conversations with court systems, they are looking at these high volume caseloads and trying to get them off of the main court dockets, because they represent an enormous amount of the total dockets, and they clog things up. And so if we can find alternative ways of resolving those disputes in a fair and ethical manner, then I think it's all to the good for everyone. The challenge there, of course, is building systems that can handle these high volumes efficiently, but also fairly.
Yeah, and then also, where do we draw the line? Where do we get comfortable saying that what the AI can do, at least as a first pass, has to be better than the current system? Like, where do we draw that line, and what happens if we hit that? And I think with AI, we're seeing that in a number of places. So in my class, I talk about, okay, we all agree that facial recognition isn't where we would like it to be, especially if we're not white guys, right? It doesn't do a good job. So, but we also know that the reliability of human eyewitness testimony is terrible, right? So at what point do we look at those things and say, does it make more sense to rely on the facial recognition, as flawed as it is, or do we throw out the eyewitness testimony? And that is that human thing where people say, I'd rather have a human judge decide this. And I'm going like, cool, which human? Like there's there's a judge I've heard of who doesn't believe in expungement. If you bring in an expungement motion in his court, you're not going to win. I would rather take my chances with AI, frankly, on that than go into that court. So I think there are some of those things. So I think what you're doing is so cool, Greg, because it pulls back and it looks at dispute resolution rather than court system.
Yeah. And I think we do have a paradigm for thinking about this, which is the appeal mechanisms in courts. And so we could have a system where there is a lot of AI-driven dispute resolution, but then you have this safety net there where if something doesn't seem right, there could be a human either in the loop or as an appeal to make sure that those errors are corrected, and we're not just completely relying on the AI.
I would say also that there's, most importantly, we think about the client perspective. Clients are not in the business to litigate. Clients are in the business to do business. And the individual humans that have a legal dispute are in they want to do their daily life. They don't want to litigate. So the whole point is option one in the old world, where litigation can drag on for months and years, whether it's in the court system, which is slow, or AAA, which is faster, but still slow-ish. So that's option one in the old world of, dragging it on. Option two is I just upload my facts and 20 seconds later, I get a resolution. Does it have to be a perfect resolution? No, because it's a hell of a lot cheaper than the old world. And if I could just get on to making more money, to doing business, and forgo all those legal fees that would have been happening for weeks and months, maybe I go with option two, not because it's better, but because it achieves my goals, certainty. That is, one way or the other, I know where I land. And then, if I want to, maybe we make option two optional and then say, if you don't like option two, go to option one, and then you can go it this way. But I think it seems inevitable that what Bridget and team AAA are doing in the arbitration route is they're building option two. And then I think that people will be able to say, you can choose which one you want. And I think that the business people will flock toward option two, and individuals will flock toward option two. And where do lawyers stand in this? I think they need to adapt.
So if
shouldn't forget that negotiation is a form of dispute resolution, and so if predictive analytics and being able to tell someone when they upload the facts, well, you're going to lose this case like with 95% confidence, then you're going to know to settle the thing. And I think there are a lot of cases where people go in, they just don't know how it's going to turn out.
Yeah. Can you guys hear me all right? Am I coming through?
Yeah,
okay.
Right.
Sorry, everyone. Internet problems. There's construction next door. Xfinity, I think, shut off our internet while they do something over there. So I'm catching up on this conversation, and I just want to say, going back to Damien's accordion method, right, where you're taking like multiple outputs and you're putting it through like like a God AI or like an umbrella, AI, like that. I think is what I'd want to see personally as a consumer of the legal system, right? So like I don't just want to throw it through AAA. I do through like their AI thing. I also want to throw it through Arbitris AI, and I also want to throw it through a third party or VLEX or whatever, right? And like I want a contract with an agreement with the other party in dispute to say, okay, we're going to run it through all these things and we're going to aggregate it, and that's our result. Right? Like that's what I want. I want the multiple AI judges coming in and like getting the reasonable output that's a synthesis of all of them, going to that accordion method, right? So that's what I want to see. And I've talked to those Arbitris AI guys, and I think it's a really interesting thing, but that's not going to be for everybody, right? Because that's like truly private court. Like that's what they're trying to solve,
Right.
that problem, which is different from what AAA is trying to solve. I think there's nuance in the difference there. But what one of my clients wanted, because again, we're trying to bring the perspective of practitioners to this as well. As soon as I told my clients about Arbitris, they were like, oh, I'm just going to run every dispute through there, just my site, and just see what it says, right?
Yep.
Like, what's the cost of that? Like, let's just do that, right? And then we'll settle. So I think there's going to be business opportunities there.
Yeah, that when I did technology contracts at MasterCard, we kind of moved away from this the jurisdiction will be in the Southern District of New York, to saying, what is it that we really want? And what we wanted was, we wanted to say, we want people to talk. We want people to settle. We'll give them a period of time. If that doesn't work, we want to escalate to their bosses. And then maybe we'll even put in escalate to the CEO level, because people are really afraid to do that. And that's going to, they don't want to do that. Then we'd say, let's go to mediation. Let's go to arbitration. If none of that works, then yeah, you can maybe go to court at that point. But there's a part of me now that would say, I almost feel that before we went to the mediation or arbitration, I would, try to get some contractual agreement to say, let's run it through some AIs and see what happens. Because the idea is like, can we speed this up? Can we increase the costs? And through contracts, can we do that? So that's an interesting thing. And then I before I forget this, and Matthew, I'm glad you mentioned this about Damon was saying about the accordion thing. So the accordion is, so in innovation, the classic thing is the double diamond, right? So we start out with nothing, we expand really broadly, then we hone it down, which is what lawyers are really good at, innovation. But then the important piece is that once we hone it down, we expand out again and then hone it down again. And that is something that AI is really good at. And so you can say, hey, I have some ideas around this, like you just run with this, and then I'll edit it down, and then we'll build it out again, and we'll come down again. And so I think that is another way that we can do these things. And then also I think we want to look at other models along these lines. And I think small claims is really instructive. I think there's a lot of stuff that can happen in family law, but a lot of those things are, sensitive in a lot of ways, and people are reluctant to trust things to AI. But we do have this ongoing experiment in China with what they're doing with their small claims, and we can kind of see some of the results there. So we can actually start to pick and choose some of these things. So Matthew, how are we on time?
We have 5 minutes left. So if everyone wants their final takeaways, now's the time.
Yeah. So let's have everybody go with like their favorite tip, takeaway, action step that they want to suggest for our audience. And let's go in the opposite order that we have been going. So Damien first.
Cool. So when I worked at, I would say our takeaway, when I worked at Thomson Reuters, one of my colleagues said, Google, if they wanted to, could squish us, but the legal market is far too small. Google's thinking in the billions and trillions, not in the hundreds of millions like legal. So Google could squish us, but it's too small. But maybe they're squishing us accidentally. That is maybe ChatGPT, Google, Anthropic, and Microsoft. How many legal questions seeking legal advice are being asked of ChatGPT every single day? Asked of Google, asked of Anthropic. So maybe it's like, an elephant accidentally stepping on an ant, that they don't realize they're doing it, but maybe a lot of that legal value goes from the legal services sector to AI without them even realizing it. Then if that's true, and I would posit everyone would agree that's true, what regulator enforcing the unauthorized practice of law is going to go after Google or Microsoft with the biggest market cap in the world, or Anthropic, or any of these, right? Nobody's going to go after them, right? So maybe the unauthorized practice of law goes away, not with a bang, but with a whimper. Because if you're a small company that is now gets sued for the unauthorized practice of law, I'm going to implead Google, Microsoft, because I'm saying I'm using them on the back end. And I'm also going to implead Google, and I'm also going to OpenAI, because if I'm practicing the unauthorized practice of law, so is Google. So these are going to be part of this one way or the other. So I think the unauthorized practice of law goes away, not with a bang, but with a whimper. And now with that, what do we as lawyers do? What value are we providing? And I think that we focus on reducing the client income threshold to say, you know, current state, I have to have $100,000 to be able to even think about hiring a lawyer. Bring that threshold down, and that's what AAA is doing, saying maybe if I can make 50,000 or 25,000, I could still afford a lawyer. And then say what the amount in dispute threshold, maybe bring that down. You know, right now it doesn't make sense to litigate anything below $75,000. But as Bridget McCormick has said, $75,000 is often for many people whether you live at a house or not, right? So maybe we bring that $75,000 amount in dispute down to 50 to 25. But so bringing down the income needed to do legal services and bringing down the amount in dispute, I think that's what we should focus on, especially if UPL goes away not with a bang, but with a whimper.
Right. Jonathan. John.
Yeah, I think my takeaway is, and I don't know the listener base well enough to know, but if anybody is listening who is considering whether they really want to get into AI or apply it to their practice, I think my main takeaway from our talk is there's really no choice. This is coming whether you like it or not. And I'm not a lump of labor guy. You know, I want to make sure Damien knows our roads are probably a lot closer than I may have come off, but I do think that the practice of law won't look anything like it did before. And I'll use this analogy, you know, accounting offices existed before Excel and before tax management software, and they still exist today, but they don't look anything like they looked before. And a lawyer an accountant who says, I don't use Excel or I don't use those softwares isn't going to be in business. And in turn, if you're just getting out of accounting school and you apply to a job and you say, I don't believe in Excel, or I think tax management software is cheating, you're not going to get the job. You know, we're going to live in a world where these LLMs and other AI products are going to impact how we practice, and we need to adapt our practices to suit them in the same way accountants did to adapt to suit the change with Excel and the change with tax management software. So we're going to change whether you like it or not. You might as well start using the tools now.
Ben.
Yeah, I think I agree with what's been said there. It's coming, and I agree that it's got a tremendous potential to democratize access to justice. And I think that large body of people who are not sophisticated legal consumers and who maybe in the past couldn't afford to retain an attorney or were just too frightened to, I think one area where attorneys still bring a lot of relevance in the AI age is in being humans. Okay. Because a lot of that unsophisticated market, what they really want, well, they really want their legal matter solved. But the second thing they want is somebody they can trust to look them in the eye and shake their hand and tell them it's going to be okay. Okay. And so I think leaning into that human element of your practice is going to be pretty important for attorneys who are going to continue to thrive going forward.
Great. How about you, Greg?
Well, I agree with all of what's been said, of course, given what I'm focused on. But just to take it in a different direction, I think we got through the whole hour without anyone saying the word GPT-5, which OpenAI just released yesterday. And I would just encourage people, whatever, you know, your preferred LLM is, you know, put it into deep research mode and ask it how GPT-5 maybe is different than what they are currently using. And, you know, I've been doing that a bit the past day or two, and it's really fascinating to dig into.
Matthew.
I'm really glad Greg brought up GPT-5 because it dovetails into what my takeaway is. But first, I want to say this is a live show. And Andrew Stevens, whose email we read in the beginning, just put a comment. He said, for the AI ARB, an option may be to add a provision that any party challenging the award in court must post a bond to cover attorney's fees and costs if the award is confirmed in court, right? So, like, there are workarounds to this. Lawyers are smart. They're going to figure it out as long as they are willing to adapt and lean in, which is what something I want to say is, we want a lot of diverse perspectives on the show. And this is just top of mind. If you're anti-AI, if you disagree with any of the things that we're talking about, I kind of want to throw it out there. Reach out to us. Let us know in the comments, and maybe we have you on next month, which, speaking of next month, it's September 12th. We'll be at 1 p.m. Central. We'll be, Legal AI Live, day after my birthday, but I'll still be there. And so keep that in mind. So my takeaway is, what I'll say is, I have had this hack kind of for a while. I didn't really realize it was a hack for getting a little bit of an idea of what the next model of OpenAI might do. And so I use a tool called Descript to produce my podcast and just screen recordings and all kinds of stuff. OpenAI is a major investor in Descript, and they get access just like Thomson Reuters and all these other, like, you know, like they said, oh, Spellbooks has had access to GPT-5 already, right? Well, so does Descript. And when they start releasing new features in Descript, it's like weeks, if not a couple of months before the next model launches. And so I just kind of have realized with the launch of GPT-5, I've kind of been able to do some more advanced stuff in Descript really recently. And it must be because they've had early access to the next model. So incredible stuff on the horizon, not even on the legal side, although it does relate to legal in terms of deep fakes and just being able to copy voices and images. So keep an eye on some other tools that are outside of legal to see what the heck is coming with AI and think about how that affects the way we practice law.
Yeah, so a couple of things. So one, I wanted to say that looking at the accounting profession, I think could be instructive for the legal profession, because one of the big discussions in the accounting world is whether the big accounting firms are going to jettison auditing. And so there's a change of what the actual practice is and who should do it and can it be done profitably. And then one of the things we talked in terms of trust, other things. But when I did estate planning work, I realized that what people were buying was not hours, not documents, not wills. It's peace of mind. And as long as lawyers can provide that, figure out the ways to do that with or without AI, I think that's really important. Then GPT-5, I think this is an interesting thing because I'm very comfortable in the tools I'm using now, which is pretty much Gemini 2.5 and Notebook LM. And I use Claude a lot. I use Perplexity. ChatGPT has disappointed me in some ways, but it's only been out one day. You're right, Matthew. Other people have been using it. So I don't think you need to chase these things as you might have in the early days. So if you're kind of comfortable with something, I would probably stay there for a little bit, but still do some experimenting. I just don't know that you're going to see something where you go like, oh my God, this is so different. Because my experience with ChatGPT-5 was in terms of my user experience, it did exactly what I did not want it to do. And so I have to figure out ways to prompt around that. So that's the other thing I would say, that as you look at AI, don't be afraid to ask it to do anything. Don't be afraid to correct it. And it's an iteration and it's a conversation. And you can say things like, I don't get that. Tell me more. Those kinds of things. You know, give me an action plan, and that will really help you. Matt, you want to sign us off?
I'll wrap us up here. So again, there's a delay on LinkedIn. So I just want to thank all of our panelists for joining us today. Excellent panel. And sorry my internet went out, but it looks like everything stayed connected. So wow, thank you, LinkedIn. Like that's like a good feature. Like if the main person who's connecting it drops, it all still is connected. So glad that worked out. And Zoom, because Zoom is powering this. Follow all of us on LinkedIn. You know, click on the bell, make sure you're getting all of our posts. We don't overpost any of us, but even Dennis had a nice LinkedIn viral post, I think, in the last month about this topic. So if you like this topic, follow all of us on LinkedIn, follow the content we're posting. Ben, I know with your new gig, you're posting more stuff too on LinkedIn, I've been seeing. So follow all of us there. LegalAILive.com if you want to get email updates and it's too much to sit live during LinkedIn in the middle of your lunch break. But you can just get 30-minute chunks. We're doing part 1, part 2 in between. We're on YouTube. We're actually getting almost 100 views on some episodes on YouTube, which is phenomenal. So thanks, everybody, for that. And with that, I have vamped enough that LinkedIn has caught up. So thanks, everybody.
All right. Bye.
Thanks, everybody.
Thanks, everybody.
Bye.